As I pointed out, the district and Supreme Courts point not only to the myth of sovereign immunity, but to federal law, specifically 28 U.S.C. Section 2680B, which reads, "The provisions of this chapter in Section 1346B of this title shall not apply to any claim arising out of the loss, miscarriage, or negligent transmission of letters or postal matter." Now, this section is a part of the chapter on jurisdictions and venue, and Section 1346B states, "Subject to the provisions of Chapter 171 of this title, the district courts, together with the United States District Court for the District of the Canal Zone and the District Court for the Virgin Islands, shall have exclusive jurisdiction of civil matters on claims against the United States for money damages accruing on or after January 1st, 1945, for injury or loss of property or personal injury or death caused by the negligent or wrongful act or omission of any employee of the government while acting within the scope of the office or employment under circumstances where the United States, if a private person, would be liable to the claimant in accordance with the law of the place where the act or omission occurred." So Congress says we can sue in federal court for loss, injury, or death caused by the negligent or wrongful acts of a federal employee. That is, except for the negligent transmission of postal matter, Section 2680B. But that violates the First Amendment, which reads, "Congress shall make no law abridging the right of the people to petition the government for a redress of grievances," which is exactly what Section 2680B claims to do. Abridge your right to petition the government for a redress of grievance. In this case, Ms. Kennan has petitioned the government for a redress of a grievance she has with government employees, specifically the actions of postal employees. But two of the three federal courts claim that a law of the United States that was made not pursuant to the Constitution supersedes the plain language of the supreme law of the land.